2017 CF 15684, back from our recess. All right, I've had Madam Clerk label question number 1, question number 2 on the back. If Ms. Burdick or someone from the state take this and review that and then pass that to Mr. Lahr so he can do the same. Thanks. Question number 1, as labeled by the clerk, I read this as saying, can we please have the transcripts from Mr. Nelson's testimony on 6/27? State and defense agree that's what the question is?
It is.
It is not.
So what I would propose is just reading the standard instruction, standard response on request for transcripts, which would be as follows. Members of the jury, you have asked that transcripts of testimony be provided for you. Transcripts are not available. However, you may request to have testimony read back to you. This request may be granted at the court's discretion. I now direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have testimony read back to you. If you decide to make such a request, it should be as specific as possible. Any objection from the state? To that being the response to question number 1.
Do you happen to know the standard jury instruction number, Your Honor?
4.4.
Thank you.
And it's number 4 on that instruction.
No objection.
No objection, Your Honor.
Mr. Nelson, any objection?
None whatsoever, Your Honor.
All right, then what's been labeled as question number 2, I read as request, letter to state's attorney, letter to Detective Ferreira, all letters written by S. Nelson. State agrees that's what it says?
Yes.
Mr. Lahr?
That's what it says, Your Honor.
And I don't know the answer to this question. Should the response be, are any of these items in evidence?
The entire letter for the one to the state attorney is not in evidence, but the excerpt is part of the stipulation. And then the other ones are not in evidence.
That's correct, Your Honor.
In terms of this when you say the stipulation, that means the document itself was not admitted into evidence? As an exhibit, and it was just read as a stipulation?
No, Your Honor, what we did was we typed, remember, this was the one that had and we typed, instead of ripping the letter in pieces, we typed what was in the letter into the stipulation. It was read by, I believe, Detective Wagner, and it was read by Your Honor.
But was it admitted into evidence as an exhibit or simply just read?
What is it?
Simply read, Your Honor.
I'm sorry, I didn't hear you.
It was simply read. That particular portion had just been specifically read by, it was shown to the jury. Detective Ferraro read it, and then we typed it, the state typed up the stipulation. We agreed to it, signed it, and then the stipulation is what the evidence is.
Well, the reason I ask that then is the proper answer to the question is that they are requesting, I cannot grant that request because they are requesting documents that were not admitted into evidence. Is that a correct answer?
Your Honor, I think the correct response would be that you have received all the evidence in this case that you can consider.
me that they are requesting something that they don't have back there, or else they would not be requesting it. I'm reading this request as being requesting letters that are not in evidence. Because there was reference in the testimony, at one point, I believe a witness was holding an entire letter, and then there was an excerpt.
65. It's the 7-Eleven.
Isn't that correct? My recollection is the letter, that there was a time where being held in the hand of various people was a letter, and then there was reference to an excerpt.
Right. It has to be that. It has to be that.
So when they say the letter in the context of everything else they're requesting, it seems to me they are requesting letters that were not admitted into evidence, because they either have the stipulation back there, because it is actually a document that's in evidence, or it's not in evidence except to the extent it was read by a witness.
Yeah. And we believe the appropriate response would be the expression of 4.3, which basically.
That's what I was referring to.
Oh, sorry. Didn't mean to get ahead of you.
No, that's,
The time.
Your Honor, we believe that the stipulation that the court is referencing, even though it's not specifically delineated on the evidence control sheet, is 159, the last item on the list. Because the item for identification that's set for GL is immediately above it and just this letter. So what was the standard instruction that you were considering reading?
would read as follows. I am not able to, and just stepping back for a moment, I'm going to read the question to them to make sure that all of our understanding is correct and that in fact we are reading this correctly. But I am not able to grant this request because it calls for letters that are not in evidence in this case. And I'm using the term letters because the either letter singular or letters plural is used by the jury in each of these requests. Not stipulation. So if there's a stipulation back there that they have it.
It would be our request to have the court, in addition to the response that you indicated, let the jury know that an excerpt from one of the letters has been provided to you as 159 in evidence.
We would object it's not appropriate to draw specific attention. I think the way that the jury instructions are written is appropriate, that they have all the evidence they consider in the case, and that's what they need to rely on. And you're not, well, the specifics of what it says, I'm not able to respond to this question. As that information is not in evidence.
Mr. Law, I understand your objection. What I would do, I agree with the defense in terms of their objection. However, the court would propose to read the entirety of this standard instruction, which was the first sentence as modified by what I said earlier, followed by, your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific question, please send another note and I will see if I can answer it.
Okay.
All right? All right, is the state ready to proceed?
Yes.
Mr. Law, defense?
Yes, Your Honor.
Mr. Nelson, you ready?
Yes, sir.
All right, let's bring in the jury, please. Good afternoon, members of the jury. Ms. Burdick, does the state acknowledge the jury?
Yes, Your Honor.
Mr. Law, defense?
Yes, Your Honor.
Mr. Nelson?
Yes, Your Honor.
All right, members of the jury, we've received your 2 notes that you passed. What I'm going to do is I'm going to read them to you and make sure that I'm reading them correctly, and then I will respond. We'll take it from there, assuming I've read them correctly. All right, so the first one I read as follows. Can we please have the transcripts from Mr. Nelson's testimony on 6/27? If I have not read that question correctly, raise your hand. All right, seeing no hands. Members of the jury, you have asked that transcripts of testimony be provided for you. Transcripts are not available. However, you may request to have testimony read back to you. This request may be granted at the court's discretion. I now direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have testimony read back to you. If you decide to make such a request, it should be as specific as possible. The second note that I have from you, members of the jury, I read as follows. Request, letter to state's attorney, letter to Detective Ferreira, all letters written by S. Nelson. If I have not read that request correctly, please raise your hand. Seeing no hands. I am not able to grant these requests because they call for letters that are not in evidence. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it. All right, members of the jury, please follow the deputy back into the jury room. Take your notepads and pens with you. Anything else from the state before we go back into recess?
No, Your Honor.
Anything else from the defense?
No, Your Honor.
Mr. Nelson?
No, sir, Your Honor.
All right, we'll be in recess until the earlier of a question, a verdict, or 5:45 p.m. this afternoon.